they are living abroad. Yeah. So, as I know that, hello, Babita, am I right?
Yes, sir, you're audible.
Yeah, many of the speaker has not joined, huh?
They've all joined. We can carry on.
Yeah. So more people are joining, and it is like something that we started this celebration in India on an international level, where we used to have a delegation from 14 countries, chief justices, first lady from US, and other high profile people used to attend. Once we write a letter to our prime minister for a message, then he started by the next year the same program on the same day. So this is the whole, and this organization is founded by Shri Jetmalani ji and Dr. Subhas Kasab ji and few other people, just ordinary people like me, with the sole intention to bring a justice to everywhere. Everywhere we found that poor people cannot have a justice, legal advice. There is no awareness. They are not, as in Europe. I have been to the US most of the time. I have been lived in New York. I have seen the people mentor the juniors. So what is it there? The sole purpose is to create a platform where there is no politics, no negative attitude, and only a networking that is, I hope everybody would like. But beside this, every of our member, we always requested to do really one good deed, good act by themselves. Society uh, will be far better without asking for it. So that's the one thing. And another is providing a women empowerment program. We have a mentorship for students. We have free legal aid and sending doing a research on behalf of the government of India, or otherwise we are sending a comment. What better and the best thing is a possible for the people? Best, we never. I'm sorry, I never use the word best because nobody knows what is the best. So I'm very humbled by the gracious presence, even though it's a virtual, of Lord Suraj Paulji. He is one of the very first few Indian to prove themselves in that era of racism. And he achieved what very few people can achieve in their life. Although many people can be much richer, but the person, I don't have so many words, or I'm not man of many words as well. But I'm really blessed that he is here with us, and I will seek his blessing for our organization and for a common youth to help us. And my dear friend James, is working a wonderful new program institute is started by the new government. Uh, that's where we lack the expertise or the international trade. So he's very good person by heart as well, and very hardworking guy. I have seen him working even though he is ill. And Babita ji is a very distinguished uh, from lawyer from Singapore. And hello, uh, I, yeah, everyone is hearing me, or I'm just speaking. Hello,
Yeah,
Babita.
we can hear you, Mr. Kaviraj.
We can hear you, Kaviraj ji.
Yeah. Thank you very much, sir. And I would take a few names other than the speaker as well. That Suman Jyoti Khetan, Rajinder Singh ji, Anand ji, and uh, even we have Kabir Duggal as well. These people are Neeraj ji, Sachin Kal. These people have been with us since beginning, and we did organize a physical conference that first time after this pandemic, Corona. So future is still uncertain because of new strain has come out. So with this, with all of your blessing, we are trying to do something, whatever we can do. But we don't allow anyone to criticize anything. It's always better to do something good rather than criticizing. And I thank you again, Saraj Paulji, for blessing us. Thank you very much, sir.
Thank you so much, Kaviraj sir, for your kind words. I also welcome Mr. Suman Jyoti Khaitan, Vice President of Indian National Bar Association. Thank you so much, sir, and thank you everyone for joining in. I would now like to start with our guest of honor's introduction. Honorable Lord Swaraj Paul, he is chairman at Caparo Group Ltd., London. He is an Indian-born British businessman and philanthropist. He sits in the House of Lords as a crossbencher with the title Baron Paul. In December 2008, he was appointed as the Deputy Speaker of Lords, and in October 2009, he was appointed to the Privy Council. Has received various awards and honors, including 15 honorary degrees from universities in UK, US, India, Russia, and Switzerland. In 1983, he has been awarded with Padma by Indira Gandhi, the Prime Minister of India, and Bharat Gaurav, awarded by the Indian Merchants Chamber. He has also been awarded with International Indian of Decade for his outstanding achievements in the field of industry, education, philanthropy at the 20th anniversary of publication of Indian Link International, which is a monthly magazine. Thank you so much, sir. I will now request Honorable Lord Paul to address the audience.
Mr. Chairman, first of all, thank you very much for inviting me. It's a great honor. And what you have said and what the young lady had said makes me believe that if I didn't say anything at the moment, I'll leave a better impression. But you have very kindly invited me. So I would like to say something. First of all, when I received this invitation, I genuinely believed that such a distinguished gathering of learned lawyers, learned barristers, judges, this, what am I doing there? I thought maybe this invitation has been sent to some wrong Lord Surajpal. Google always nowadays come to the rescue. I looked at it that there is no Lord Suraj, another Surajpal, because Suraj was a name which was given to me when Mahatma Gandhi launched his freedom movement, Suraj, We Want Suraj. I was born in 1931. And my parents, who were very much supportive of Mahatma Gandhi, they named me Suraj. Suraj, you all know from India, means freedom. Then
बेसन का हलवा बना के चाय बना के ले जाओ तो बेसन का हलवा बना दूंगी
स्वराज पॉल बोल रहा है
है
लॉर्ड स्वराज पॉल
when you are
थोड़ी देर में बोलेंगे पॉइंट पॉइंट करके
then your editor Kavita Sharma came to my rescue on the telephone.
अभी जिन्ना 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 ना हो गया क्या हो गया बवाल
So
इतने साल से जिन्ना याद नहीं आया
I will request everyone to mute your mic, please.
I would have liked to be present in person. Firstly, because the conference is being held in India, a country I am proud of to be from there. And secondly, this is where today government is headed by Mr. Modi, who in my view is admired in India and all over the world for making the Indian economy and stronger, and what India used to be blamed for corruption, mostly corruption. I would like to congratulate Mr. Modi and his government on that achievement. All of you know that I was a very close friend of Mrs. Gandhi, who was a great prime minister and was generous enough to offer me ministership with a choice of portfolio. I also remember today one of the great names of Indian legal world who I knew personally, like my younger brother, Mr. Arun Jaitley, and my condolences again to his wife and family. I wish COVID had not come on the way of my being able to attend the cremation. Would you please excuse me? If not, I am able to name many of the eminent lawyers from countries other than India who are here today, such as the Honorary Justices of the court, past and present, who are with us. I would, however, like to mention eminent barristers whom I have known of, including Bholabhai Desai, Nani Palkiwala, Mr. Sirbai, Mr. K.S. Kapoor, Mr. Nambiar, K.K. Venugopal, Motilal Sedabad, and Fali Nariman, Soli Sorabji, Harish Salve, Dr. Abhishek Singhvi, Ram Jethmalani, the only one Ram Jethmalani, the Gopal Subramaniam, K. Parasaraman. Not only have they done great service for me, for the Indian legal system, but they have provided great service to the country. My own experience of law is having been a chancellor of 3 eminent universities in Britain, Wolverhampton, Westminster, and West London. They have great law schools and students who are not only practicing in Britain, but in India and the United States. In all these universities, we do get a lot of Indian students, and we are very proud of them. I have had experience in a different way. I meet many lawyers in UK, US, and other countries and discuss with them issues of government, business, and many other areas of law. This has enhanced my knowledge of the world and helped me to make sure that business is both honest and respectable. During my 25 years in the House of Lords, I have met many distinguished law lords and barristers. And of course, finally things go to the Privy Council. When these subjects are discussed in the House, I am also acquiring knowledge of the law and without having to pay for it. 2 typical cases in which I have been personally involved over the last 60 years have been matter of great pride for me. I certainly had to pay the bill for these, both for the case in India and for the case in Britain. Both have become important cases in business and taught in almost every country. I refer to the Caparo case in the United Kingdom, which is also referred to as the Lord's Rajpal case. And the other is the DCM and the escorts, which is a well-known, is almost every judge as well as lawyer in India at least. In India, after both DCM and escorts invited non-residents like me to buy their shares, the companies then decided not to register the shares which I had bought. What scared them was that those people controlling the companies held only a minority of the shares, the balance of being owned by the institutions. And I ended up having many more shares than they did. The case went to the Supreme Court, and the companies briefed the most eminent barrister in India, at the time, Mr. Fali Nariman. Eminent barrister, even his case did not convince the learned judges to accept this argument. Mr. Nariman must have been very disappointed, as he was not used to losing cases. In Britain, it was the Caparo versus Fidelity case. I bought the company called Fidelity, a manufacturer of televisions, the second largest in Britain, and we found that a large quantity of stock was missing, almost 12 million pounds. The auditors, Tushrosh, now called Deloitte, denied responsibility. The case went as far as the High Court and then the House of Lords, which in these ways, now it is termed as the Supreme Court also in UK. At that time, the House of Lords was the final court. We did not win in the House of Lords, but eventually Rosh decided to pay our expenses. The House of Lords decision was that Rosh did not owe any money to Caparo because the auditors had the duty only to the shareholder and to the company. Unfortunately, the company was worse because we had already bought it and unfortunately paid for it. Oh, sorry. Even today, whenever an accountant or lawyer meets me for the first time, they ask me about the case. And I always say that if I got a pound for every time I am asked a question, I would be a rich man. It hasn't happened so far. In India, we have a great tradition that we value the law and respect it. That is why it's the culture has the respect for the other country. In 1945, a lot of you, I'm sure, weren't even the trial of the Indian soldiers who decided to fight the British. On the refusal, the British government marshaled them. Even the British judges ruled to hang them. The most famous law at that time, including Bhola Bhai Desai and the late Nehru and other eminent lawyers, called to appear on their behalf. The soldiers were all released by the courts with great honor, and the country celebrated. Since then, the tradition of law in India has been respected. People like Justice Bhagwati have been great justices of the Supreme Court, and I have had the pleasure of knowing them and also their daughter. In that last few years, I am pleased to say that a lot of Indian girls have gone into profession and earned great respect and honor, such as I mentioned, Pallavi Shroff of Shardul Amarchand Mangaldas and Company. Today, lawyers all over the world are in the front line in defending human rights and political freedom. This is a role that is not often understood by the public at large. I hope that these activities will become better known. I also hope that all of you will continue this commitment, particularly at this time when there are ever-increasing threats to liberty. All of us who value democracy and rule of law owe your profession a debt of gratitude. I hope that the next generation of lawyers will continue and expand these activities because in the end, human liberty depends on law. It's also evident that all over the world, a new economy is being created. New currencies, new types of exchange, new ways of doing business, new concepts of censorship are evolving, new kinds of new definitions of law to keep up with this. I hope that your profession will give a lot of attention to this, because without adequate law, the new country will be more chaos. Before I finish, a most important point. While I was discussing with one of my legal friends, Jim Duncan friend, Spencer Fine in US, he told me this story. One of his late colleagues, who was quite prominent lawyer in St. Louis, often liked to say, I really don't care about wanting to be known as the best lawyer in town, but I do want to be known as the most expensive. Good luck to you. So I told him that this was my fear, that I find myself paying for the name and the advice and not the advice. I am sure none of you would do that. I would like to thank Dr. Subhash Kashyap, President of the INB and former Secretary General of the 7th Lok Sabha, whom I have had the privilege to know and consider to have been a very competent General Secretary. I know that he is not here today, but best regards. Many thanks to you, Subhash, for giving me the opportunity to speak to this distinguished gathering today. I know how difficult the job is. We in Britain call this job of chief clerk, both in the House of Commons and in the House of Lords. A strange difference in titles. I had the privilege of being a Deputy Speaker of the House Lords, acting as Speaker in the Chamber, and the Chief Clerk was a great assistance to me. I can imagine the demands of your job. I do not yours. The most wonderful thing I enjoyed as the Speaker is because Speaker in the House of Lords doesn't say a word. All you do is you get up, then every member, whether he has a seat or not, has to sit. If he finds a seat, he can floor. Ladies and gentlemen, it has been a privilege and a pleasure to see you and talk to you all. I have been present in, I could have been in present day. However, I would be delighted to meet any of you. If you come to London, have a cup of tea with me at the House of Lords. It's the best place in the country, and quite reasonable in cost. And I won't charge. So, ladies and gentlemen, if you have any questions, please feel free to ask. If you ever want to write to me anything, any advice, it will be an honor and a pleasure. My address is in the House of Lords.
Sir, Your Lordship, that Subhash Kashyap ji and Ram Jethmalani has been always mentoring me, and they usually call me as a friend, but I never cannot treat them. They have been so senior to me, but usually he is having a certain health issue, Dr. Subhash Kashyap ji. I know he purchased his first car, Mercedes, when very few people had the Mercedes. He used to work in UN and he left that job. Just came to India Gandhi ji to serve the country. I have seen him not to say word nowadays have changed my mindset because they did a lot of work for free and have a best intention towards the India. So I will ask any of the participant if they want to ask a question to sir, and then we will ask the Subhas Kastabji. I am going next month because once his health is improved. So we will have a conference call along with him. He is also very old now. So please, everyone who want to ask anything.
Suman sir, please unmute yourself. I think you're trying to say something. Suman sir, please unmute yourself if you want to
Yeah,
say
I'm Suman
something.
Jyoti Khaitan. I'm glad to hear the good words from Lord Surajpal. I'm also from Calcutta. A lot of his family members still are there. And I've also met Lord Surajpal during the celebrations of his elder brother, which is every year hosted by his niece, Shushmaji Balia. And I met him there, and I know of his family. I am a lawyer also of Shushmaji Balia and Vijay Balia. And they have beautiful children, all studied in Stanford University. And I'm very glad that his father named him Swaraj after the freedom movement, which is a good reminder of the great service rendered by his father and all his brothers. And being from Calcutta, we all know how his brother used. The reputation was that his brother owned all the buildings in Park Street, including a very famous confectionery Flurries. And everybody from Calcutta, of course, loved Flurries, and they still go there. And it is hearing Mr. Lord Surajpal was like nostalgia coming back, the good days of Calcutta and Delhi both. And I also had the honor to know his late senior brother who started this APJ school in Delhi, which is now being run by his very accomplished daughter, Shushmaji Belia, who was also the president of PhD Chamber. Subsequently, I also became the president of PhD Chamber. And I've had the good fortune of meeting and dealing with many of his family members. So I just wanted to bring this to the notice of Lord Surajpal. And of course, a lot of Indians are now staying there. Of course, he was among the first to go there. And I remember I went to London Zoo, and he had made a memorial in the memory of his late daughter. We visited that also. So Lord Surajpal has done India proud in England when few Indians were there. Now, of course, he has led by example. A lot of Indians are there. So it's a very great honor and privilege to hear from you. And we hope to meet you whenever you are in India next, or we have the good fortune to visit London. It's nice to see that you're maintaining good health. Thank you, sir. With good wishes.
Thank you very much. I used to know Mr. Bhakti Khadan like my elder brother because he was very close to Jeet Paul. And also I used to go to his chamber and also go to his house lots and lots of times. I am sure rather I would have met you, but please excuse my old age for this that I may not remember. But he was a great man and he was a pillar of Calcutta.
Sure.
Then do please, when you come to London, meet me. A lot of people from Calcutta always come and meet me, and we have a lovely time, remembrances. At APJ schools, as you know, my brother used to look after it. It's my niece, Shushma Barlia, who at the moment is in charge of that. But I am very much associated with it.
Thank you, sir. Thank you.
And I would also, as a senior advisor to the organization, I would also like to thank Lord Swaraj Paul for getting back the memories of, by remembering Ram Jethmalani ji and Fali Nariman we still have with us. We are blessed to have his presence still. Respected Honorable few other members sir is also mentioned, so it's great to hear from sir all the big names that of his age, of course, who have been with us. But two of we also, like sir also remembered the Anil Devan was also one of the members. So that legacy is somehow on. Ram Jethmalani sir is there, the son is there, and Anil Devan. The families again, Sham Diwan sir is there, and then we from the Nariman family, we are still blessed to have Fali Nariman, and sir is active enough still. Last when we met before COVID, so he was healthy and fair enough. And I don't know if Lord Swaraj is aware, his son Rohinton Nariman, who was a solicitor, has also served as a justice in Supreme Court, Honorable Rohinton. Just visit and stay connected. As you mentioned, Subhas Karwal. So we Honorable Minister for State for him as well as you. So we'll just convey the regards and just try and connect you there as well. Thank you so much, sir. Stay connected, and we would love to, if you can, be with us till the end of the conference. Thank you so much. We'll come back to you. Over to you, Yashika.
Mr. Ram Jethmalani was a class himself.
Yes.
I have not come across any barrister who can be compete with Ram Jethmalani.
Definitely, sir. Definitely, that's true.
He was a great friend. His son, sometime when he comes to London,
Mahesh, sir. Yeah. Mahesh.
he does come to see me.
Mhm.
Soli Surabji, we were really very close.
He's also worked with Gujarat, and Soli Surabji is still, he's okay on his health, carrying on. So we still have. So we want to stay connected. Yes.
He has for me. He also, every year he used to come to London and walk from where he used to stay, come to my office. We always had a cup of tea or go for lunch around the corner in some restaurant. And is he still alive? Because I haven't.
Yes, sir. Yes, he is very much alive. He is very much alive, and he's doing okay health. Few of his,
Because
yes,
someone told me that he was suffering from COVID or something.
No. If I'm not wrong, Ketan sir is here. Sir, he's very much alive. Soli Sorabji is there. Sham Diwan's father and Anil Diwan is no more with us. And Fali Nariman sir is doing well.
Vinakshi ji, आपने क्या कर दिया? Soli ji is no more.
Oh, I am so sorry. My apologies, sir. Then I'm on a miss. I'm on a miss on this. Yes. For 2 years, it's like, yes. I'm on a miss. My apologies, sir. Yes.
What happened?
My apologies. I'm not aware of Mr.
I know because I used to work and he ultimately succumbed to COVID, sir.
Yeah. Now that's what I said.
He had COVID, then he succumbed.
Because
my heartfelt apologies, Sumanji. That's why I'm saying if I'm not wrong. Yes. My heart. Yes. I was just not.
No, Soliji was 90. He completed 90.
Oh, okay. Yes, I'm not aware of.
We are we were the same age, and he was a lovely man. Harish Halve, of course. But apart from that, he has acted for me. Mukul Rohtogi acted for me. But Harish, his father was a great friend of mine, Salve, N.K. Salve, who was minister also. I don't know whether. girl who is most important at the moment in the world is Kamala Harris. She
Yes.
the
Yes.
Vice President of the United States. Rather, I am building a new plant in Texas. I have written to her that Kamala, when we are ready, I would, and if time allows her, I would have her.
I work with the New York Governor Office.
So can you talk a little louder, please?
Yeah, I have worked with the New York Governor Office as an advisor to New York Governor, as well as very well connected in US, and I did find her to be she might be an ex-president. She might be. Joe Biden may not complete his tenure. You must have heard about his son.
अरे कविराज जी ये सब चीज आप Zoom में मत बोला करिए, everything is recorded.
No, when you are in a parliament and very active in the politics of Great Britain, you have to be very interested in the British American politics. And my largest business is in US.
Oh,
So
good.
I have to be in touch.
But sir, we would like to invite to India.
Pardon me?
We would love to invite you to India.
My second largest business is in India.
No, I'm not talking about your business. We are not talking about business. We are inviting you as a person, as a good person.
I love India. I am very proud of India. And I used to go to India at least twice a year before the COVID.
Yes, sir.
Only in the last 2.5 years. And when this COVID finishes, I will come. I'll be glad to write to this thing, Weber. And if you would, I would love to meet all of you or some of you and have a discussion.
Yeah. Thank you very much.
I am honored that you invited me. I feel more comfortable that you invited me. Otherwise, I was very afraid that what am I going to do with the distinguished lawyer?
Yeah.
On a few things, you are still updated sitting there. And my apologies once again. I've suffered a lot during COVID. I myself had COVID. So for quite some time, so that could be the time, and I'm not on Facebook, LinkedIn, Twitter, and other things. But it's my apologies once again, because being a jurist, if I mean, sir has worked a lot for the state of Gujarat. I've had in many matters, I've heard him, for the arguments and otherwise as well. And he's one of those big 5-7 big names in Supreme Court and other courts as well, even internationally. So my apologies once again. So I'm sure nobody is going to hold it, as, because it is a time I've missed on, and it's a bad miss on my part. So thank you so much once again. So carry on.
So Rajendra ji is there? Rajendra ji?
So he will just, yeah.
Yes,
Yashika,
I'm
you
there.
can carry on, please.
Yeah,
Sir,
yeah,
you
yeah.
I'm there,
please.
sir. Kaviraj, I'm there, very much there.
Yeah. So he is one of our great supporter as well, and doing a lot of pro bono work. So I would like to say that working for a poor people, giving a free advice, he spent quite a lot of money on that.
Thank you so much, sir. Thank you so much for a word of appreciation.
Yeah, please say something to ask if you have any question.
Yashika, please carry on.
Now I would like to welcome our keynote speaker, Ms. Babita Ambedkar, who is the head at CMS India desk in Singapore. She specializes in cross-border M&A capital raising, new market entry, joint ventures, and restructuring across Asia Pacific.
Yes, Babita, we can hear you. Please
Hi,
carry
can you
on.
see
Yeah.
me?
Yeah, yes, we can see you. A very warm welcome.
Great.
Please carry on.
Thank you. So thank you
Babita,
firstly to
can I say
INBA.
something? Can I say something, Babita?
Oh, yes, please.
Yeah, Kaviraj. You know the like a Jetulani, I'm a naughty guy, but you change your look.
Yes, and I have a very futuristic backdrop here as well
Yes.
to match the topic of the insights that I'm going to be sharing today. But well, I wanted firstly just to say thank you to INBA for hosting this event, and it is particularly kind that you have opened up this opportunity for those of us who cannot be there in person. So appreciate that initiative. And secondly, it is wonderful to be in the presence of such distinguished speakers. So I very much look forward to hearing what everyone else has to say at this event. But my topic is really on something fairly modern, and hence the backdrop. The subject is contemporary issues in the age of digitalization. I think this is a very broad topic, firstly, but I thought that I would share some thoughts, loose thoughts and insights that I have based on the practice that we do internationally and what we're actually seeing transpire from a legal perspective. So firstly, look, I think we're in a world where digitalization is causing immense change on a number of fronts, and legal issues are just one. And while we have tremendous benefits from digitalization, there's also a catch-up that we need to do in terms of infrastructure, in terms of governance, in terms of thinking. And I think this leads to a very interesting stage that we are at, where there are many challenges in that certain things have not been anticipated, certain developments there is no governance for. And I thought today maybe I can sort of share some ideas on some of those. So having thought about some of these issues, I think that the key one, which I encounter on a regular basis, is the question of contracting. And what better a case study than perhaps the e-commerce sector, which is a base example of where we see digitalization, and we experience it on a daily basis. So firstly, I think the first issue that I can see in this space is determining the capacity to buy. How do you determine whether the person that is contracting is able and has capacity to actually buy and enter into an online transaction? Well, the reality is this is incredibly difficult to determine. And I think the biggest concern is that the contracting party might not be of age. So for example, we do have a number of incidences where there are minors who contract. And of course, the youth are all very open to online transactions. And so this is a big issue for the e-commerce industry. I think the other big issue for this industry is risk, in terms of risk of fraud and identity theft, which is becoming increasingly an issue. And I'm sure that many of us have been subject to attempted scams and attempts at identity theft. So what solutions present themselves at this point? Well, I see e-commerce companies grappling with this on a regular basis, but some of the conventional methods that they have adopted are going through a process where the buyer needs to complete certain personal details. And they also need to communicate and enter payment methods. Now, the challenge is that it does mitigate risk, but not substantially enough. So I think in addition to this, what we are seeing is that risk is being mitigated through the introduction of presumptions, exemptions, limitations of liability, and the taking out of insurance on websites, etc., in terms of the contractual representations. The second issue that I see with this example of e-commerce is jurisdiction. Reality is that the activities that occur on the internet are worldwide. And the various entities in the chain, so the e-commerce platform, the warehouse, the bank or the payment services provider, and the customer may well all be in different jurisdictions. Now, from a legal perspective, determining jurisdiction in relation to the transaction is fundamental for a number of reasons. Firstly, the enforcement of rights of the parties, the resolution of disputes, considering the intellectual property protection that applies, considering consumer protection laws, and even data protection laws. So there's a raft of things that, from a legal perspective, jurisdiction is important for. Reality is that it may, however, be impossible to verify the customer's location. Now, where goods require physical delivery, often an online retailer can restrict its customer base to jurisdictions where it does deliver to. But with online goods, digital goods and services that are delivered online itself, this is really almost impossible. And the reality is the retailer may just have to rely on the information that the customer is providing. I think other contractual issues that I see, particularly in the e-commerce sector, are when is an offer made? When has an acceptance been communicated? Does the website constitute an invitation to treat or an offer? And when is the contract actually formed? I think these are fundamental questions, and the reality is there is no clear answer on many of these. Well, this actually moves me neatly on to the next thought that I wanted to share, which relates to the execution of contracts. Now, the reality is over the past, 2 years, we've all moved to a model of executing digitally much more than we did before. But the reality is, while e-signatures can facilitate transactions, they can potentially be tampered, modified, or forged. So what are the key factors when we're determining the enforceability of e-signatures? The first one is intent, because intent really provides a legal context for enforceability. The e-signature process, to determine this, should ideally provide a structured online setting. So it would take the signer through a series of steps or make it clear that they're signing a legal document and attempt to confirm intent through overt actions. And this could be, for example, having a digital signature that's created and it's applied to various locations in the document online. The second factor is proof of identity. How do we determine this? So an e-signature system should ideally, again, use a mechanism for assuring that the person who completes the e-signing process is actually the intended party to the contract. Systems such as DocuSign may provide an and user authentication, which is fantastic. However, it's obviously not foolproof. I think in this instance, we do the best that we can. Third factor is the ability to repudiate. And I think examples of attempted repudiation around a digital contract could include, someone made changes without my agreement. That's not my signature. I didn't sign that. I didn't see that section of the contract. There's many, it's much easier for this to be an issue. Again, how I think we deal with this is that the e-signature process should provide a strong audit trail that captures the content, eliminates the risk of subsequent changes, and creates some form of indisputable association between the contract, the date it was signed, and the parties who signed it. Now, of course, while we have many documents that can be signed digitally, there are examples of documents that still remain where it's wet ink. Wills, instruments, trusts, powers of attorney declarations, and conveyance of. And that actually brings me on to the next thought that I had, which was on smart contracts. Now, for generations, our whole concept of contract was something in a document in paper that's tangible and is actually signed physically. But that has all changed. On top of e-signatures and signing digitally, we also have a new concept called smart contracts. Now, what are they? Well, they are actually blockchain protocols that automatically execute complex and enforceable agreements. That's a concept. And what happens is, and the contract self-executes when those conditions are met. So it's an automatic process. And the idea is that smart contracts purport to create an automated execution system that constitutes a legal contract that a court would or should be willing to enforce. That's the concept. But at this stage, despite the benefits of that, I think the reality is that a few of us would really embrace a smart contract model, a traditional language contract in favor of a code. And most likely, if these are to be implemented and where these are implemented, they are implemented in a hybrid manner. Will always be some form of actual contract, and then some mechanisms would be automatically executing. It's important to remember that I think for certain contractual arrangements, it would be difficult to implement a hybrid model. So they may well continue to be executed in a traditional means, or in certain instances, purely automatically. With smart contracts, from a legal perspective, well, jurisdiction and governing law I see as a challenge. So blocks in the blockchain, as many of you will know, are distributed across nodes all over the world. So even if a smart contract expressly selects a certain governing law, the question is whether that selection will be valid in lieu of the actual location, or most likely locations, of performance. The other issue that I see is that although blockchain was created partly for the purpose of enabling a stateless world as such, it doesn't actually address how disputes are resolved when there's a conflict. I think in a simple sense, where there's a performance of a contract that is signified by payment, for example, the outcome can be remedied by a refund. But the reality is the solutions are not always that simple. So I think dispute resolution remains a key concern. And until smart contracts are able to deal with these issues such as this, they won't, in my view at least, replace traditional contracts. I think the final thing that I see on smart contracts as being a challenge is the application of data protection laws. It's really not very clear how they apply to blockchain. There are, for example, those who mine. And it's not clear whether miners would be classified as data processors, for example. Would participants within a network be regarded as having consented, given their consent to that, being party of that and sharing their data? Is the processing of data here necessary for the purposes of exercising a legitimate interest? These issues are all yet to be determined. The other key issue is that when data is stored on a blockchain, it is immutable and cannot be amended. Now, a key compliance issue raises itself here because a number of jurisdictions have data protection legislation that often requires organizations to accede to requests to make corrections to data or to remove their personal data. And that really, actually, practically is not possible in the blockchain. Talking about data more widely, I come on to another contemporary issue that I see in our current age, which is the subject of big data. big data has had its day in the media on a number of occasions, and I think it is a very interesting area and subject, and people have views for and against. But from a data perspective, I think I'd like to just comment that, you know, what I see as issues from a legal perspective are that while under privacy laws, technically speaking, the data controller is accountable for the treatment of data. But when you look at big data, which is essentially utilizing algorithms, does this mean that the data controller would also be, in principle, accountable for algorithmic decision-making? How does that work? How can this apply from a practical perspective? This would not, in my view, seem viable due to the complexity of the algorithms on a technical level, the mathematical or the system language that is used to build the algorithm itself, and also issues of contextual dependence. So, I mean, algorithms operate on a complex, layered and random interconnected level. And so accountability, that whole concept of accountability being with a data controller seems obtuse. Other legal concerns that I see here. Is the data being processed classified as personal data? That's a key question. It is often asked with this area. Who are data processors accountable to? I mean, again, is it the decision makers should be accountable to, algorithmic decision makers should be accountable when they process the data? It's not clear. It also should be noted that the purpose of data processing, when you're looking at big data, may change almost instantaneously because algorithms actively search for new purposes to make use of the data. And that again doesn't sync with data protection legislation and what it's envisaged. The other concern that I see is a potential for abuse here. And we all know of this Cambridge Analytica issue that was encountered a number of years ago with the Trump campaign. And that's just one example of the potential for abuse. And finally, I see an issue with the potential for bias with big data, but I'll talk about bias a little bit later because the final topic that I wanted to address today was the use of AI. Now, AI has the ability to really transform what we do on so many fronts, but there are challenges with AI from a legal perspective. The first issue that I see is the question of legal responsibility. Unless liability can be imputed on a party, the actions or omissions of AI will remain beyond legal sanction. How can courts determine the state of mind of a wrongdoer in this situation with AI? How do you impose the test of the reasonable man on AI? These are very, very important questions. As AI evolves and has the mind of its own, to what extent can its actions be attributed to those of its makers? Can it be said that the creator of a technology embedding AI had caused the wrongs committed by the AI when the AI's intelligence has evolved and it's no longer bound by those algorithms that the creator had made? I don't think there's an answer yet for these issues. And even the device that's possessing the AI, the hard device, is that to be treated as an employee of its creator, for example? And does it impose vicarious liability on the creator? These are all very lateral questions, but important questions. I'm going to draw in a case study here. The case study, which was the example of autonomous vehicles. Also shown that electronic information that's collected from vehicles is a key component in determining whether the fault of the accident is attributable to the human or the machine driver error in autonomous vehicles. There's a case study that some of you may be aware of a few years ago when a pedestrian was killed by one of Uber's self-driving cars as she crossed a road in the US. Now, sadly, although the vehicle safety systems failed to identify the pedestrian as a collision risk, the backup human driver was found to be at fault for the death. Data from the dash cam videos showed that the driver was repeatedly looking down at her lap in the final minutes before the crash. The other electronically stored information showed that the driver was streaming a television show before the crash. The car's data also showed that if the driver had been paying attention in this instant, the accident could most likely have been avoided. But realistically, if you are purchasing a car to self-drive, you can see the challenge that there is here, which is the whole idea is that the car self-drives, and therefore you would not necessarily do the same things that you would if you were driving the car itself. However, the reality is that under the law, that is what you need to do.
Bhavita, I have one more question about.
Oh yeah, sure.
And there is a judgment when the AI-driven car has an accident in US court. But the judgment is not very clear to me. I'm not as good as you are. And another thing, when I had a meeting with the Albany Law College as well as the management dean, they hosted me in Albany.
Right.
So what this ask, every company is coming and asking, once somebody enter into the store or try to Google or try to search anything, to correlate the entire my history, that if I am 1 month pregnant, so they will give me something else, because 1 month pregnancy cannot be recognized by the eyes. What is my profession, you cannot recognize it. So when you go about the facial recognition software or something like that, lawyers cannot keep updating so frequent to understand the implication of it.
Yeah.
And this corona has endangered the entire population. Flu, it is already accepted that the flu was created by the scientists. They already admitted, there's no question about it. But there's a still question about, some say they invented it, corona, or somebody says they have not. So we can't go political and say uncertainty. Question now comes is, infertility rate has increased so much, which India proposed to say that they have a population growth. Now what they have? 1.2%. It means most of the couple doesn't have more than one child, and many of them doesn't have any child. And this is a world over phenomenon. So in a future, if the company is asking and tracing and tracking, and there is a law, already law, that Microsoft should not store entire data at one place. That's fine. However, there is one more question comes here. Data is in a cloud. Location can be anywhere, right?
Yeah.
But it can be combined.
Yeah.
Because unless it is a combined, you cannot have a seamless experience. Nobody working in a Microsoft will say this. Some of the retired or resigned from Microsoft said yes, it is not possible to segregate that data. So in this world, what's happening now? We are in an uncertain position. We are becoming consumer. Is there any chance in another court litigation in US, one of the tech company forced to shut down their news journal just because they did right against him? Because they keep filing cases, and that company could not afford money to pay to their lawyer. So what the role lawyer can play in this era, and what is the future?
Mm.
That's that's very scary. They can be, if they know me better than me myself. There is another example is, you might be aware that one company, I will not take a name, I don't believe in it, supported in 10 countries political party, and 99% won the election. How they do it? Because the data is always there, but you could not study it, analyze it, or interpret it. But AI making it possible, right?
Yeah.
So it's a very blatant. I'm asking a very straightforward question. Are we going to have a, I will not say dictatorship, but on, we will be owned by someday one company, or we will continue to have a democracy? We can't have a democracy because they know too much too far. How will you react to certain reactions?
Well, I mean, this is the issue, right? I mean, and this is going back to the big data, and also actually it draws in the last thing that I had wanted to talk about, which was bias and interpretation of data. Actually, I think the fact that there is so much knowledge, subliminal knowledge, as well as overt knowledge. We all, I think we all have the assumption that we only share with social media and whoever else may be monitoring. We only share what we want to, because we actively choose when we want to make a post. We actively choose when we want to like something or react to something. So we think that that's the extent of tracing that can be done, or knowledge that someone could ascertain about us. But that's not true. People can ascertain when we open emails.
Yeah.
People can ascertain.
Bhavita, I'm not talking about the social media as well. If you use a secure browser, you will know 1,000 trackers are tracking our activity on internet. It is not the only social media from where they are getting information.
That's right. Yeah. It's anything that we do.
All the Aadhaar card information in India is handled by the private company. Same in US, same in Europe. So when these hackers can crack all these websites, how the banking fraud happens like this. So citizen, as we see after this dean of the management courses in Albany, when everybody is asking how to assess it, how to analyze it, we need these students to go. Things have changed too far.
Yeah, certainly. And look, that's the reality, is that data, they say that data is the new currency. And it's really true. Data is so valuable. It's the most valuable commodity now. And that's the world that we're coming to. So the protection of data and the treatment of data and what happens when there is an issue with respect to data is going to be something that is critical for all lawyers, whatever practice you practice in, wherever you come from and whatever jurisdiction you practice in, it is going to be critical.
And another thing is a US Senate hearing. Google clearly told them, I have a mobile over here. They know. Where is my mobile? If I move to another room of my office, they will know it. Right? But they don't use it. But they store it. If you delete a website, then they have another mechanism, archive of websites. They will tell you, this website looks on Friday like this, Saturday like this, Sunday this, Monday this. So it's a multi-layering, and the blockchain concept is, I don't have a server. It is hosted on every mobile or every computer. So does it look to you a scary word, or you think we can find a solution to it? So data is there, anybody can accept it.
Yeah. It's the world of uncertainty and a world which is new. And
Yes.
there's many things that could take place or happen with the apparent use of data and the ability for data of very unknown, or unthought, from unexpected sources to be utilized. And I guess, look, it is our role to discuss with governments and, to the extent that it's possible, apply regulation to protect society at a base level.
There is one more question. When you started this topic, I don't need the internet to access the internet services. I can use the GPS. I can use another mean. We have 1,000 leftover satellite. If you hack into one and direct it to any country, it's more dangerous than a nuclear attack. But the government is doing. So we have to come together now. Ask. These rights or laws, when we say right to privacy, the right to be forgotten, how can you enforce when they have a data in a layers? Is it possible? When you have archives, then another archives, still data is available. And then when you don't have a server, it's jumping from one to another, and another. So any law, right to forgetting or privacy, can work.
Yeah, so that's a critical question. I mean, the law says that it should work, but in practicality, you know, how can you actually tell whether it has worked? How can you tell whether erasure has actually happened? You know, how can you tell whether you have really absolutely no signature left with an institution that has stored your data? It is very, very difficult. And the challenge is that those who would be implementing, so technically speaking, the role of this administration is given to data protection officers or a nominated person in an organization. They won't necessarily, they will typically be compliance people, be experts from a technological perspective. And so understanding from a system is not easy for them to do. And bridging the gap with the technicians is another challenge. So I do see this as a very big challenge, actually.
Yeah, if I delete and say a data from a mobile, you can still access it. So if I remove it from my server, doesn't mean it is not there. So the people and the businessmen, so what these tech companies are doing, CIA has a fund that has funded a few companies to change the human behavior, social reaction. It is a public data. When the government is supporting it, what you can do?
Yeah, exactly. This is a massive challenge. And how it's dealt with, we don't know. I mean, this is what we're living at the moment.
Yeah. So, thank you very much, Babita, but you are as uncertain as I am.
Absolutely. Which is why these are contemporary issues.
Please send me an article on this. It's a very interesting topic because what the government is claiming and this company is promising, there is a huge gap. I have seen an example in US. Senator presented a bill printed on certain companies' letterhead or held this purpose. If they are winning election based on the money of businessmen, so the next step, they are a king. So what you would like to comment on it?
Sorry, was there a...
Would you like to comment on this? That when the US Senator presented a bill written on the letterhead of a business association or a company letterhead, they're not caring even that it has to be presented on their letterhead or on a plain paper. What you would like to say? I have been a speaker on FCPA on many issues, particularly Asia. I spoke about it in Australia, Singapore. So I have so much to say with you that
Well, sorry, the last point, I didn't quite, we were talking about FCPA.
Yep. I told that I've been a speaker on FCPA in Singapore, Australia, US, and I chaired and being even an organizer. And the another thing is that when a senator present a bill to be passed by US Senate, presented then what's the law? It means they are so careless, or if the case is made out against the FCPA, under the FCPA, against these senators.
Sorry, Kaviraj, you were cutting out. But I have to say that FCPA is not so much my topic.
Okay.
But you know, happy to defer the discussion.
Yeah.
Maybe to the next one.
Yeah. So we will talk after this conference. And I did like your new look, and I think I'm getting a message. Other speaker is waiting.
Of course.
Yes. Thank you so much, Babita, and thank you, Kaviraj sir. Over to the next speaker, we have Rupesh Jain waiting with us. So, Yashika, please take it forward. Thank you so much.
I'm so sorry, I was muted. Really sorry. I would like to welcome our next keynote speaker, Mr. Rupesh Jain, who is the Deputy Vice President, Legal and Secretarial of Johnson Controls Hitachi Air Conditioning. So kindly address the audience. Thank you.
I hope you can hear me, Yashika.
Yes, so you're audible.
Okay, thank you. So,
yes, sir, you're audible.
Thank you
Please
for handing it over. Yeah, thank you. So, distinguished speakers on the panel, fellow legal professionals, learned audience, ladies and gentlemen. First of all, let me thank INBA for inviting me and giving me an opportunity to talk about this important subject, you know, corruption in private sector, or as we internationally call a commercial bribery, which though extremely relevant to all the organizational globally, it gets somewhere ignored without realizing its wholesome impact. So I would say corruption is everywhere. It seems like, you know, corruption is a necessary part of functioning of society. Corruption, I would say, tops as the most important problem across the globe, much more than unemployment and terrorism. And it is one of the main agendas in elections around the world. We always hear talk about and, you know, relate corruption with corruption in public sector only, like the bribery to government officials, you know, to seek favoritism, and in common parlance, get our work done. Private sector, and it's something we see and relate with, but hardly talk about, thinking that it may not affect us. So I would say, when there is a monopolistic power to do something, that corruption may happen. now whether it is a public sector or private. What happened during demonetization, all of us saw what kind of corruption happened in banks. Every common person got impacted. So while these are broad examples and people just forget once the situation subsides, I would say the more routine ones like favoritism being done in sourcing decisions, the procurement contracts in private organizations, the fudging of accounts and records, the passing of dubious insurance claims, the borrowings from banks without proper due diligence, improper valuations to gain commercial benefits, and cartelization are just few of the commonplace examples of corruption in private sector, which I tend to ignore and accept them as our way of life. Sometimes we see examples like certain people in who are in position to raising queries, hiding the real agenda in their mind of corruption. So what happened was, during a very recent survey, 60% of the organizations globally admitted that maintaining standards of integrity in times of rapid change is a significant challenge. And 1/3 of them also agreed that corruption is a major risk impacting the long-term success of the organizations. So all this,
Sir, Rupesh, I'm sorry to interrupt.
Yep.
And I'm not known for Rupesh. I'm not sure. It's a Japanese company.
Yes, sir, it's a Japanese company.
Yeah, there is a one tradition.
Yep, please go ahead.
Certain officer favors certain company, and they hire him after 1 year or 2 years.
Yes.
That's got a name. I'm just forgetting it. That name. Can you tell me that name of that practice? That's very particular to Japanese.
I'm sorry, I'm not able to relate, but yeah, maybe after this, I'll talk to you about on this.
Okay, you don't want to talk on the conference. So
okay.
Thanks.
Yeah.
Thanks, sir. Thanks.
So moving forward, so as professionals, whether working in-house or as external consultants, our role is extremely important to supplement the effort of organizations to curb these kind of corrupt practices. So with this theme in mind, I'm going to talk about the need for making corruption in private sector a criminal offense. During my session, I'll brief what is the impact of such corruption, the challenges identifying corruption, and what's the legislative and like what we should do, and what role professionals and then amongst individuals is always a race to reach to the top. The consumption, we all of us know, they all add up and make people vulnerable, and people do fall to the lure of quick results and shortcuts, like adopting unethical means. And the focus, I would say, is more on short-term gains, how to make more profits in a short term, and cutting corners, and all this at the cost of long-term sustainability of the business. And this problem gets bigger when there is an absence of proper internal controls. So should we say that private sector is corrupt? Well, I would say, no, it's not so. Organization per se are not corrupt. It is the people and the environment, the lack of checks and balances in the system, which may lead to corruption. I would call it the opportunity, as we talked about regarding demonetization, the COVID situation, how private entities try to extract as much money as they can from the common people, and also coupled with the inaction on the part of organization whenever a corrupt practice is found. The lack of whistleblower mechanism that prompt wrongdoers to continue to flourish, continue doing what they are doing. More importantly, that these actions are not so far punishable offenses. What is happening is the system is allowing them to do whatever they want to do, and they continue doing that. So I would say that if the organizations operate in an environment which is corrupt, the private sector may have inclination to be corrupt. If you give a clean environment to a private sector, there will be no corruption. So the need of the hour is to make the operating ecosystem clean. And I think if we make corruption in private sector also a criminal offense, it will encourage the development of a clean ecosystem. So coming on to the what is the impact of such corruption? Is that usually we think that it is private money, so we are not concerned. I would say this is an extremely wrong thought, and even if it is not public money, it raises costs. So we must understand that all corruption has a cascading effect on the prices of products and services, and it hence impacts each and every one of us and stifles the opportunity for honest people. Similarly, when it comes to international trade, it makes us incompetitive. Corruption also causes massive reputational and brand risk for the organizations and leads to losses in revenue. So this is what corruption can impact the organization and common man in a big way. Coming to what are the challenges identifying corruption, I would say corruption. Why because it's a very complex crime, it's very difficult to detect. Babita spoke about how technology is growing very fast, and it's kind of outwitting the legislators' thought process, let alone talk about their action. So the money trail is very convoluted process, and accessing of multitude of bank accounts, and then pursuing and identifying the corrupt transaction, and coupled to that, you have to analyze and a multitude of email threads, chat, mailboxes of a lot of custodians, and it does require multitude of sophisticated skills and expertise in order to manage. So a lot of forensic expertise, and it goes without saying that it's an expensive process. So how the governments across the global environment handle corruption in private sector? So to start with this, FCPA does not specifically prohibit commercial bribery, but an involvement of a listed entity in a commercial bribe will expose that entity under FCPA's criminal and civil books and records and internal control provisions. And similarly, there are other provisions in acts like Travel Act, anti-money laundering statutes, and tax laws, which also prohibit commercial bribery. As far as United Kingdom is concerned, we had lots of Rajpal today. So Anti-Bribery Act in UK criminalizes the bribery of foreign government officials. It also has a broader scope than FCPA, which prohibits commercial bribery. When we come to Singapore, The Prevention of Corruption Act there makes bribery by individuals and companies in public and private sector. So they equate both public and private sector, and they constitute it an offense. More recently, closer home, Chinese government has proposed some amendments in their AUCL, which is anti-unfair competition law on commercial bribery, and as per the amendments, it would prohibit commercial bribery for the purpose of obtaining business opportunities or competitive advantages in private sector. In 2017, the GCN, that is Global News, Global Compliance News, covering 74 countries, and it found that in 54 out of the 74 countries, there is a specific provision which makes commercial bribery a criminal offense, and in 5 more countries, in certain special circumstances, commercial bribery becomes a criminal offense. So, like when there is a nexus to public body, so then it becomes a criminal offense. So only in 15 countries commercial had any specific criminal provision, and interestingly, out of these 59 countries, Qatar, UAE, giving punishable. So like you have IPC, like cheat issues, sections on cheating, on fraud, and then we have section 408, which talks about criminal breach of trust by an employee. So these kinds of cases can be covered under those kind of provisions. We also have, like SEC in US, we also have SEBI regulating listed entities. So very lot of insider trading regulations or reporting requirements if any fraud is identified in the company. In fact, in coming business responsibility and state sustainability report requirements, which is BRSR, one of the principles on which entities need to report is that have businesses conducted and governed themselves with integrity and in a manner that is ethical, transparent, and accountable. So, and it complaints filed with the professional bodies, our competition commission, where you can file complaints about these cartelization. So even in public sector in India, corruption, for public sector corruption also, only individuals are liable. Like I gave that example of that GCN survey. So in India, only even for public sector corruption, only individuals are liable. There is a 2018 Prevention of Corruption Act where organizations have been brought under the ambit, but the rules there have not been notified, and so making it still enforceable. Yeah.
Rupesh,
sir.
I'm sorry to say that our another speaker has we did not expect that the audience will enjoy this much, this discussion, but we did beyond the point. And I'm in your government set up by this new government. We will continue, but he has to leave to another country. He's not in India right now, but another country. In India, you can be late. It is accepted. But you cannot accept in European or
So, would you like to say
I will
something? Yeah, please.
ask you. So please take few
I'll
minutes and then we will ask him because he
sure,
has to
sure,
go to
Kaviraj,
the
I'll
meeting.
wrap it up in 3 to 4 minutes. As I said that, when it comes to legislation in India, in 2018 amendment, organizations were brought into ambit, but the rules have not been notified. Similarly, in 2018, one bill on prevention of bribery in private sector was to make bribery in private sector a criminal offense, but is yet to see the light of the day. So to bring organization in the ambit of prevention of corruption, simultaneously bills such as the one introduced in 2018. So it defies logic as to why some act which is committed in public sector is a criminal offense, but not so when it is committed in private sector. So if an act is considered as a criminal offense in all the domains. So moving on briefly to what organizations should do and what professionals like us can do is like setting up internal controls, setting up robust ethics and integrity cultures in the organizations, good code of conducts, whistleblower mechanisms. So set up due diligence of vendors and partners, reviewing commission and particularly consultancy fee payouts, and doing stringent background verifications and reporting the concerns of unethical behavior to prospective employers reaching out for background verification. Certainly, one thing I would say that the organization should not adopt a tolerative attitude, set examples by taking strict action in whatever limited framework which we have available in India. And as governments, cannot counter corruption in private sector.
Rupesh,
Yeah.
what you have pointed out is the most relevant point. Most relevant point. And as a INBA, we would like to have your written submission. So we will submit it to the government of India.
Great, wonderful.
And we'll look personally. I'm looking forward to your suggestion personally, and I'm quite sure we are. I'm not anywhere. Nobody knows me, but my mentor knows peoples. I will ask them personally to deliver it to and invite you along with it to present to the government. So, Rupesh, I would like to invite now James Nedurappa. He is the head of Center of International CITL, I will say in a short form. He is very young person. He is very hardworking. I have seen him working just like I don't use a word that I wanted to say. He is a man of a ethical plus hardworking and the intellectual guy. This institute is set up by Modi ji for a certain very specific group. That's where we don't have any specializations yet now. I'm James may differ because he is from the government Ministry of Commerce. I'm quite sure. But James knows me. And his boss also knows me that I strictly say what is true, what is right, and what is wrong. James, sorry. You know me. Please, James.
Thank you. I hope I am audible.
Yes, sir, you're very much audible. And apologies, conversations went ahead from the very beginning. So we really know you have to leave for a meeting. So please, without taking much time, please carry on. We can see you and hear you very nicely.
Thank you. Thank you, Vinakshi, and thank you, Kaviraj. I'm extremely sorry to take the to cut short actually the presentation of Mr. Rupesh. I happen to be in Geneva for the WHO ministerial meeting, and there are some problems as well here. So anyway, I would like to talk a little bit about international economic disputes. At the same time, I would like to congratulate all your efforts very, very closely with
James,
yeah,
you're looking smarter and younger now.
you know that I'm smart. So, but anyway, let me try to finish it, Kaviraj, I think, because I'm running short of time. So we can have this chat back. Would you mind that?
Never. I will mind that. I will.
Thank you. Thank you for all the compliments. So, I'm going to talk a bit about international economic dispute resolution. So basically from the point of view of state-to-state dispute resolution, like the WTO dispute resolution, and to an extent, investment arbitral decisions as well. So we know that when the COVID happened, I think at that time, most of the hearings actually happened physically. And we know that most of the hearings actually happen either in European countries, like in Geneva, in Switzerland, or in London, or in Paris, or in some of these countries, in fact. In fact, international dispute resolution was highly, I think, specific to certain locations. But when COVID came, initially, I think countries were very hesitant in having this kind of virtual hearings. But we know that, in the context of state-to-state arbitration, nothing can be done without the consent of the state. So even with respect to physical meetings or virtual hearings, I think most of the countries had their own reservations. So initially they hesitated. So they said that some of the meetings can be done on a virtual format, but most of the substantive hearings will have to be done physically. And I think that kind of a pattern was going on for a long time. Initially, most of the international tribunals, I'm talking about the WTO panels. So the WTO panels actually heeded to the request of both the parties, and especially the respondent party, because the respondent party in natural circumstances would like to delay the proceedings and to the extent possible. So in the early period of the COVID, most of the tribunals actually asked for a specific consent, and most of the respondent parties said that they would like to delay the proceedings. So the proceedings were delayed, but we knew that COVID is not going to end very soon, and now this is COVID-19. We are not going to end in 2022. So at least we have already gone through this crisis for nearly 2.5 years. So what will happen in the future? That is the real issue. So my own hunch is that now most of the tribunals are going to actually impose virtual hearings against the consent of the parties, and this has already happened in some disputes. And the respondent parties invariably said that this is actually a breach of due process. And their argument is that due process entails a physical hearing opportunity. And their argument is that physical hearing opportunity presents ample amount of time for parties to express their views. It also gives them enough opportunity to check with their own colleagues and people of the delegation. And nothing can basically substitute a physical hearing. But the reality is that, because of the travel restrictions, now we are again going to enter into a different phase of COVID because of the emergence of the new variant or new mutation. So we never know when will the physical, I think the international travel will resume on a normal basis. So possibly it could actually be delayed by maybe by 1 or 2 years. But disputes, especially of commercial character where business interests are involved, will have to be resolved quickly. So now the concern here is that how can this process be made, consistent with the due process requirement, especially with respect to making, proper oral or verbal arguments. And then second, the most important thing is that the confidentiality of the process, the confidentiality of the documents, none of these things should be impaired or, I think, compromised. This is a very important concern, actually. Because we have seen that in virtual hearings, sometimes even uninvited parties who may not have anything to do with the dispute, sometimes get access. There is also a fear that some of the proceedings may be recorded online by the parties, although it is completely prohibited. So these kind of things actually happen. So the confidentiality of the process can be impaired beyond repair. So two things are currently happening. So I have been involved with some of the free trade agreement negotiations. So in some of the free trade agreement negotiations, there is a clear, I think, explicit language in the agreement, providing for conducting this kind of hearings virtually. So sometimes, there is an explicit language that the hearings can be done by teleconferencing, video conferencing, by phone, by other protocols as well, or other communication devices as well. So that is, finding a place in the agreement itself. Sometimes, these kind of things may not find a place in the agreement, but they may be part of the working procedure or rules of procedure. So anyway, I think what is going to happen in the future is that the blended form of hearing will become a very natural thing. And in many ways, it has got a lot of advantages as well. Online hearings can be done from any place at any time. It is absolutely time-saving and cost-saving. So these are some of the plus points. But again, we have to actually, we have to temper it with the reality that nothing can really substitute physical hearing. So that is actually a major challenge. So all arbitrators, either part of the state-to-state dispute settlement or state-to-investor dispute settlement, or even as part of commercial arbitration, will have this challenge. And we have to also look at the fact that some of the Switzerland has actually got a procedure against this kind of physical hearings in their civil procedure court. But some other countries, commercial arbitration for that matter. Although I'm not an expert in this area, but I should say that both this category, physical hearing and virtual, happen together at the same time, and that is why we need to be extremely flexible. So, and in order to provide a specific provision for that, the procedure to be amended. Sometimes the treaty agreements will have to incorporate a specific language providing for a blended hearing. Anyway, these are very, these are trying times, and these trying times are not going to end anytime anytime soon if you go by the latest emergence of the variant. So my own suggestion is that these kind of principles can also be adopted by the local jurisdiction. I'm sure with respect to criminal offenses or getting a bail or whatever, virtual hearings are absolutely essential. But when it comes to commercial matters, the rights of the respondent parties cannot be impaired. And I have also participated in a number of number of virtual hearings. And although, now the platforms are really good, the technology is wonderful, the kind of interruptions or disruptions in the proceedings are very minimal. Nonetheless, my own feeling is that it doesn't have the same kind of efficacy as that of a physical hearing. So normally in a state-to-state dispute, the proceedings are slightly different in nature. There could be, maybe more than one arguing counsel, and there could be a long list of people in the delegation. For instance, if it is a dispute involving a state, multiple ministries or interministerial departments may be involved. So when a question actually is raised to the counsel representing the matter, then they may have to cross-check and verify with the parties. In a virtual hearing, sometimes parties actually do on the basis of chat comments, or sometimes they, pass messages on WhatsApp. But these are, I think, suboptimal. So nothing can really substitute physical hearing, but at the same time, nobody can delay the proceedings saying that our due process is very important. So virtual hearing is a reality, it is a must. So I will stop here, and in the interest of time, and since I have to go for a meeting, thank you once again to INBA and to all the distinguished speakers who spoke before me. Mr. Rupesh, I'm very sorry to come into your speech. Please, I really apologize for that. And again, Vinakshi and Kaviraj Singh, my sincere, I think, compliments and congratulations for this event. Thank you.
Thank you so much, James sir. It was really nice. I know we took more time and you would have you have got lesser time, but we can continue the conversation sometime later on the other events as well. It is really nice to have taken time out from your busy schedule and been with us. Thank you so
All
much.
cheers.
Over to Oberg, if Oberg wants to. Thank you so much. Yeah. Oberg sir, you want to say something, please? Over to you.
James and Rupesh Jainji, I would like to say something to both of you. Rupesh are you there?
Yeah, I'm very much there. I think Mr. James left.
No, James is not left. James.
Kaviraj sir, James left. He had he had to rush for some urgent meeting for the very purpose. So.
Or WTO.
Hello. Everyone hear me?
Yes. Rupesh sir, do you want to add on something before we take up with Mr. Oberg?
No, absolutely not. No, it's all right.
I will
Absolutely
here
not.
in between, but just because of the
times,
the conversations go here and there. So
yeah. No, I appreciate it.
I just wanted to see if my microphone is working right now. Can anyone hear me?
It's perfectly working fine. We can hear you.
Yeah, that was my problem. I just arrived in India and to connect all the things, I didn't have all the right equipment, so I have to use a special microphone for this one. Anyway, it has been very interesting talks here today, and I like to hear it. And I just wrote a note about this, that in the court in Sweden, we have now this possibilities during the COVID was developed, where we have the conference through the telephone lines, where people can be in different places. And telephone lines, I say, that's the technical part of it. It's normally okay. I am Caparo representing INBA in Europe, and working with developing business between India and Europe, and I am also a judge in the Stockholm Administrative Court.
And you are also director in a largest Swedish company, public sector.
No,
you still.
No, I have some companies. Yeah.
Yeah.
Yeah. So what I am saying is that we have the technique has come very far, and I think we had a discussion yesterday also when we have the Constitution Day, therefore the advocates and juridical what problems might be techniques, and I think we all have to see the possibilities but also the problems, the issues, the challenges. And I think the previous speaker, we had a few steps back speaker, had pointed out this problem with the who is responsible if something goes wrong, if the technique takes over. And I think this is something we all need to work. I believe I was muted by someone.
Yes, you were muted for.
Yeah. So others would. I think I would like to just put it in, but I think it's on my mind after this discussion we had yesterday on that meeting, and what I heard here today is that see what's happening after the COVID with the human rights and what is a human right and all the things. This is a big challenge that I think we need to talk about, because we have seen people demonstrate against closing down countries during the pandemic. So is that something that should be a human right to do? And when they at the same time break the rules, or is it okay to do like that? And we also see people spread a lot of fake info regarding COVID and fake info regarding taking vaccinations. And it starts an interesting question, I think, juridical, that I would be interested to hear what a lot of you think about in when we ever give a time for such a discussion, because we are in a specific situation where human rights has been set aside in different ways during the COVID thing, and what you can do, what you can't do compared to earlier, and what you saying and what effect it has. Not only that you're allowed to say something, but it can affect the lives of others. If someone doesn't take vaccinate you because someone said it was dangerous, then maybe that person who heard it will expire in COVID. So I think we need that kind of discussion, juridical discussion. What do we think about human rights position? No, I will just be that short today because with this equipment, and I thank you for that.
I need to unmute me. When we talk about the Swedish people, they invite you for a dinner, and they will have a dinner and everything, but will not talk. Is very well apart. And when time they are leaving, they will say, thank you very much. It was very nice meeting you without meeting. But my dear friend, over is not like that. I never like to sit next to him when he is driving. Over, am I right or wrong? Can you tell? Oberg? I think is have again technical issue, so we can close.
Sir is trying to unmute himself.
The problem is I have to switch between different systems, listening and talking. But Kaviraj, I didn't catch you fully, what I was to confirm.
Okay, we are not able to hear sir as well. So on behalf of Indian National Bar Association, I thank all the participants and having all the patients throughout the second day of the conference. And it has been wonderful having you both days. So I think you're a better person who's been present physically as well as virtually, along with Suman sir and the others who are with us today. And thanks a lot to Rupesh sir, Jen, and James is now already left along with the on behalf of INBA, thank all and the Secretary General of INBA for organizing such a wonderful conference for us all. And it has very informative conference for the students, for the lawyers, law firms. So
And
that is all
industry.
good to be seen.
Industry.
Of course, yes. Yes,
Yeah.
the industry as well. So we've had the
And
distinguished
future
jury with
world.
us throughout the conference. Yes.
And I really must say thanks to personally Oberg and James for bearing me and listening to my talk.